Isn't buying a car a thrilling and perplexing experience? Make sure you understand your state's lemon law, so you don't get taken for a ride on a high car repair bill or fall prey to lemon law myths. Hello, this is Alpha Law Firm, and in today's video we'll debunk some common lemon law myths and explain how they work. But first, kindly subscribe to the channel and switch on alerts to be notified of new videos. Whether it's your first car or your fifth, there's a certain sense of delight and satisfaction in driving a new car off the dealership lot. It's spotless on the inside and out, smells brand new, and handles like a dream. Everything is wonderful. That is, until it isn't. Your new vehicle could be a lemon if you have a severe problem with it that persists despite several attempts by the dealer or manufacturer to repair it. Lemon, you might be wondering. Car? Okay, we'll assist you with that. So the Song-Beverly Consumer Guarantee Act, sometimes known as the California Lemon Law, was created to protect consumers who purchase or lease a car or used vehicle with the manufacturer's original warranty. If your vehicle is judged a lemon, you may be entitled to relief in the form of a refund or a replacement automobile under this statute. This rule is in effect for the duration of the original warranty period provided by the car manufacturer. How will you be able to meet the lemon criteria now? While every state has a lemon law, the California lemon law presumes that a vehicle is a lemon if it meets any of the following conditions within 18 months of purchase or 18,000 miles on the odometer, whichever comes first. You bought or leased a new or used car from a California dealer. You brought the automobile in for the same problem many times during the factory warranty term. The dealer has made attempts to repair the vehicle many times, but the problem persists. The issue is so severe that it influences the vehicle's use, value, and safety. The manufacturer is permitted a reasonable number of repair attempts under the California Lemon Law. What constitutes reasonable varies depending on the circumstances, but in all cases at least 2 attempts at repair are required before a claim can be filed. So what will you do if you believe your car is a lemon? To safeguard your rights under California's lemon law, you should take the following steps. Notify the vehicle's manufacturer or dealer of the issues you're having with it. Keep track of the nature of the issues as well as when they first appeared. As quickly as possible, take your vehicle to a dealer or manufacturer for repairs. Save all repair-related paperwork. Don't rely on the dealer or manufacturer to maintain them for you. Contact an attorney as soon as possible. If the problem remains after several attempts at correction, many manufacturers fight lemon law claims vehemently. So obtaining skilled legal counsel early in the process can improve your prospects of reaching a satisfactory settlement. It's vital to remember that filing a lemon law claim has a deadline. If the deadlines are missed, you may forfeit your chance to utilize your California lemon law rights. Keep in mind that you should think about your settlement possibilities as well. The warranty is the responsibility of the manufacturer, not the dealership, and the manufacturer would be responsible for the refund or replacement of your vehicle. As a customer, you have the right to receive the total amount paid for the car, which may include a mileage offset deduction. Alternatively, if you want to obtain a replacement car, the manufacturer must provide you with an almost identical vehicle to yours. You may have to pay for additional options or aftermarket products out of pocket if you want them. So if that new car scent is turning foul due to unfixable faults, use the California Lemon Law to safeguard your consumer rights and get behind the wheel of a reliable vehicle at no cost to you. Consumers, judges, and lawyers frequently misunderstand California's lemon legislation. Many fallacies about California's lemon law were spread by a booklet distributed by the California Department of Consumer Affairs many years ago. Though well-intentioned, it led many customers to feel that their lemon law rights had expired sooner, or that some of the criteria were unclear. Unfortunately, some of these misunderstandings persist today. Don't be deceived. Don't take the word of an unlicensed practitioner or an armchair attorney. Please keep watching and give this video a thumbs up if you want to learn more about these fallacies. And feel free to express your ideas in the comments section below. Okay, so it's relatively typical to hear that if you buy a used automobile, you won't be able to file a claim. For 2 reasons, this is a myth. To begin, you may have a monetary claim under your state's lemon law. However, it may not involve vehicle replacement. Second, your vehicle may be covered by a manufacturer's warranty, or you may have had issues with it in the past when the warranty still covered it. Bottom line, lemon laws were enacted in every state to protect consumers, so don't think you're out of options. That is a decision that a knowledgeable attorney should make. It's also possible that your dealer will inform you that you don't have a claim. To tell you the truth, lemon laws are intended to protect the consumer, not the dealer or manufacturer in every state. So an attorney specializing in lemon law is the best person to determine whether or not you have a claim. Dealers are, at the very least, unqualified to make such a decision. At worst, they may be acting in their own self-interest, as dealers are compensated by their manufacturer to do warranty repairs rather than replace lemons. Suppose your dealer has tried 3 times to fix your car but has been unsuccessful. You may believe you are entitled to a refund or replacement at this point. Before recovery can be evaluated, several aspects must be considered. They include the severity and persistence of the problem, the number of days the vehicle is out of service, and the frequency of dealer visits. Because no 2 cases are alike, yours will be addressed according to your specific set of circumstances. You may believe, or someone may have informed you, that you are no longer eligible to file a claim after the problem has been resolved. This too is incorrect. The fact that the car's fault has been rectified is not among the criteria determining a lemon law claim. Often the problem is resolved, but only after an excessive amount of time and service, trips to the dealer, and inconvenience to the owner. Even though the fault has been resolved, such a car is likely to be a lemon. Consider the possibility that a fixed problem may resurface long after the dealer appears to have solved it. You may also believe that you must file a claim within the legal mileage or time constraints. This is a myth. Some states require you to report the incident within a certain amount of time or mileage. Taking the car to the dealer for repairs counts as reporting the problem. The claim can then be lodged for more time and miles than the law allows. You believe you have 3 days to change your mind after purchasing a vehicle. Okay, this one is logical, but it is mostly untrue. Standard auto sales contracts do not include such a clause, and offering one would not be in the dealer's best interests. So before you take possession of the vehicle, make sure you understand all of the paperwork associated with the purchase. Also, make sure you want the car because you won't be able to return it. If you believe you can just leave the car at the dealer because you don't want it, and it'll be their problem, think again. This is not the case. You are responsible for the vehicle regardless of how you obtained it, whether you purchased it outright, leased it, or financed it. The dealer will frequently sell their interest in a leased or financed vehicle to a leasing or financing company. As a result, the dealer is not the owner in any of these instances. If you leave your vehicle on dealership premises, you may face the following consequences. The dealer may charge you for storing the vehicle. Because you would still be the legal owner, you would be responsible for whatever happened to the vehicle while it was there. If you stop making payments, the finance company may take it back. They may potentially sue you for the difference between what you owe and what the vehicle sells for at auction. A voluntary repossession would be sent to the credit bureau on your behalf. Leaving your car at the dealership is a horrible decision in every way. You believe your vehicle's maintenance is the responsibility of the dealer or manufacturer. Again, not true. You are responsible for the car and its maintenance once the transaction is completed. Monitoring and replenishing oil, coolant, and transmission fluid, and maintaining tire inflation and rotation are all part of this. Even if service is performed incorrectly on your car, for example, your tires are overinflated at the local tire shop, you are responsible. The dealer is solely responsible for repairs covered under warranty, which typically do not include vehicle maintenance. So study your owner's handbook thoroughly and take note of the recommended maintenance times and mileage. Remember that the lemon law is in place to protect you. Don't be misled by disinformation and take the appropriate subsequent measures. If you believe you're driving or nursing a lemon, see an attorney who's familiar with the law. Don't get stuck with a lemon. The law is on your side. That's it for today's video. Remember that this is not legal advice and does not constitute attorney-client relationship. Call now to learn more. 323-51-LEMON, 53666. Don't forget to hit the subscribe button and to turn on the notifications to be notified of every new upload. This is Alpha Law Firm, and we will see you in our next video.